On the main list, item number 1.
Yes, madam.
My Lord, the matter is still pending in Supreme Court, my Lord. Matter is still pending in Supreme Court, my Lord.
All right. Yes, please take it over. On the same ground as mentioned in the order dated 14th November 2024, this writ petition is further adjourned till
March.
10th February.
Matter has been listed for final hearing in the Honorable Supreme Court on 15th January, my Lord. 15th January.
We have kept it on 10th February.
Yes, my Lord. Blush, my Lord.
Item number 2.
It's been served.
Yes, I may appear on behalf of respondent.
How many days delay?
165 days.
Maybe allow next date for filing for objection. Today I'm filing a
Why you are opposing the prayer
opposite
for,
party.
you are opposing the prayer for condonation of delay?
No, I'm filing for objection for condonation of delay.
If it is objected to, we have to give directions.
Yes.
Learned counsel for the respondent opposes the application for condonation of delay of 165 days in preferring the appeal. Paragraph, accordingly, the following direction is made, : affidavit in opposition by 31st January. Affidavit in reply by 14th February. List the appeal along with the application on 17th February.
Item number 3.
This is an appeal under Section 37 of the Arbitration Act against the order of the Learned 34 Court dated 15th February 2024.
Yes.
My Lord, the Learned 34 Court upheld the award qua all our claims except setting aside the pendentalite interest and the pre-suit interest, pre-arbitration interest in the matter. So this appeal has been filed on this limited aspect, whether the said could have been...
Is there any cross-objection by them?
No, my Lord. They have not filed their cross-objection. In fact,
They have accepted the rest of the award?
Yes, my Lord.
Paid?
Yes, paid, received by us. There is an interest element that is disputed, that is pending before the executing
On
court.
what ground the Learned court
Yes.
disallowed the pre-reference and pendentality interest?
My Lord, the primary reason was that 31(7)(a) says with consent of parties. So if there is an agreement between the parties qua interest pre-award, then interest cannot be awarded. That is the settled law by the Honorable Supreme Court, and I'm not going to waste my time by...
GC Roy and all those cases are
my lord, yes, my lord. Manraj and other cases subsequently, but yes, GC Roy is the initial case. My lord is absolutely correct. Now, my lord, there is an exception to this, which has been created by the Honorable Supreme Court in the case of Susaka. Now, in that judgment, my lord, they said the concept of waiver was introduced by the Honorable Supreme Court, where they had said on two grounds that if you do not object when the reference is being made in section 11 or during arbitration, qua the interest, or do not bring...
Was there any agreement between the parties for interest?
My lord,
Pre-reference.
No, there is no pre-reference interest specifically. There is just a clause which talks about damages and interest. That too is very vague. In fact, this Honorable Court has said that it is too vague for a judgment of this Honorable Court in another matter on an identical clause. I said this is too vague for interest not to have been awarded, and upheld award of pre-reference interest in that case. I will show that judgment also. Before I show the document, the relevant clauses, I wanted to take my lord through the Supreme Court judgment, if my lord will permit.
You want to argue the appeal today?
Yes, it was listed for arguments today, my lord. We've already filed the convenience compilations as directed by my lord.
All right.
Very well, my lord. Can I pass on to...
I passed it on.
Yes.
With Honorable Judge, do we have a special list, like matters which are specially to be heard by us, or this is the only list? This is the regular list which Justice didn't know. But please finish the matter by Friday,
Absolutely, my lord. I shouldn't
because
be...
this bench is only sitting till Friday.
Very well, my lord. I'll definitely do that.
My lord, we have little problem, my lord. Can it be, my lord, in the first week of February, so that my lord can hear the matter and dispose it of, my lord?
Keep the dates accordingly.
My lord, we have already some matter fixed and all that, my lord. It will be difficult on our part to stay back and all that, my lord.
No,
Your lordship kindly...
when he is ready, let him proceed. Then we can make it parted before us, and whenever it's convenient to my brother, we will sit in February and hear it out.
Okay. Yes, sir.
So let them complete their part. Let them complete their part, my lord.
Time comes, then we'll do it. Time comes, they're going.
4 and 5 are the only two matters left. Okay. Just pass over for a short while. Call item number 4.
Item number 4.
Next, with their last experience in the bar. Kishore Kumar is originally from the Sikasar. Below Tarun Geberi. Who's in item number 4?
But I am for the appellant.
Yes. Is ready for hearing.
My lord, this matter, because of subsequent development, my lord, this is a matter will lordship recollects is with regard to seizure of gold, my lord. And
that matter,
my lord, because so-called notice, they say that so-called notice was not issued within 180 days as required under the section 110, my lord.
yes, sir.
Our case was that the so-called notice was signed within 188th day, my lord, but because of law and order problem in Manipur, it could not be.
I think we passed an interim order not to
Interim
dispose
order.
of the gold.
My lord, now what happened, my lord, in the meantime, because the lordship has not stayed the adjudication before the department, my lord, the adjudication order has been passed, and the order has been passed for confiscation of the gold, my lord. So now, in that view of the matter, in my humble submission, this matter has become infructuous, my lord. They have to contest that adjudication order if they want to, my lord.
If this writ was directed challenging the search and seizure.
No, my lord. This was directed only against very specifically that because SOCO's notice was not served on them within 180 days, so the department is liable to restore the gold to them. But this is in my humble submission, it is something like default bail, my lord. If a charge sheet is not filed within 90 days or 60 days, they are entitled to bail. But now after trial here, they have been convicted, my lord. So I can draw an analogy, my lord, in that view of the matter, my lord.
Lordship, I pray that the matter may be passed over for the day, Lordship. Because I have to take instructions also. Let this matter come on
Then,
Monday.
since Justice Dingdo and myself
My lord.
had substantially heard this matter, we will keep it on Monday.
Yes, Lordship.
My lord.
All right. Since this appeal was heard to some extent by the bench comprising of myself and Justice Dingdo, we direct that this appeal be placed before that bench at its next sitting.
My lord.
Let's call item number 5.
Item number 5.
My lord, in this case, spouse is suffering from this serious kidney failure and requiring execution of hemodialysis twice in a week.
My lord, here we have challenged the order passed by the learned Central Administrative Tribunal. The matter pertains to grant of medical allowance, my lord. Otherwise, the matter is ready for hearing, my lord. But the other matter, your lordship, is passed over.
I think this also we had heard.
Your lordship, an interim order has been passed, my lord.
Then, my lord, one interim order was passed to keep the
15 lakh rupees.
15 lakh should be deposited against this proceeding.
That we have
But
done.
I am having this outstanding payment. I have already submitted 11.5 lakhs. That should be released.
We will be sitting on Monday. We will take up the matter on Monday. I will be sitting with Justice Dingdo on Monday onwards. So we will take it up on Monday.
Monday I will be out of station, my lord.
Monday, Tuesday.
I will be out of. So the only direction there for outstanding release of outstanding.
All right, you ask your junior to be here and apprise the court. We will.
Okay.
We will do the needful.
Okay, much obliged, much obliged.
Same order. Not the previous. We call the passed over matter.
Second call. Item number 3.
Before I begin, I wanted to point out one thing. My lord, on the last date had said that matter will be heard today and tomorrow. That is why we had planned that trip accordingly from Delhi. But if just only about half an hour to address argument because it's a very limited issue. Will it be because I wanted my lord to be my lord to like hear the arguments fresh from both sides at the same time, just so that in case of a rejoinder, if my lord,
You start the matter.
Very
you
well.
start the matter.
very well,
You have full 1 hour's time today.
much obliged. So, sir, well, there is a judgment that has been passed over of the Honorable Supreme Court by the name of Union of India versus Messrs. Susaka Private Limited.
That is all right. You must give us the facts.
Yes, very well, ma'am. I shall do that. Just that, very well.
What was the contract between the parties? That
Absolutely. I understand what is falling from my lord. Just that this judgment is giving an exception to the generally laid down norm. So I wanted to apprise my lord of this judgment. But if my lord wants to know the facts first, I'll do that. Yes. My lord, there is a list of dates. Have you handed it over? We've prepared a short list of dates for my lord's convenience. Yes. This issue is now 30 years old. As my lord will see the first list of date, it is 12th June 1995. This is when the respondent had floated a tender for construction of the civil work of a power plant. Sorry. Yes, my lord. Called the main plant and auxiliary building of the Agartala gas turbine power project.
You see, the issue is very short.
Yes, my lord.
Now, as far as the general law is concerned,
Correct, my lord.
let us share it with you.
Yes, my lord.
That interest under the Interest Act can be claimed under 2 or 3 circumstances.
Correct, my lord.
Number 1, agreement.
Correct.
Number 2, notice
Right,
under
my
the
lord.
Interest Act.
Right, my lord.
And number 3, if it is statutory.
Yes, my lord.
Say you get it under the Sale of Goods Act.
Correct.
All right.
Absolutely, my lord.
Otherwise, you cannot claim interest.
Yes, my lord.
There is no equitable right to claim interest,
Right, my lord.
pre-suit or pre-reference.
Correct.
Now, pendentity interest from the date of institution till date of decree or award is governed by the principles of section 34 of the CPC.
Correct, my lord.
The court has the power.
Absolutely.
And so is the power for post-decree or post-award.
Absolutely, my lord.
Now, if the Supreme Court judgments have said something else,
Yes, my lord.
now, in
Yes.
recent judgments,
Correct.
please let us know.
Yes.
And as far as pre-reference or pre-suit interest is
Correct.
concerned, whether there was any agreement between the parties for interest or
Correct.
notice under the Interest Act
Yes.
or statutory,
Yes.
I think these are the
Absolutely.
issues.
My lords, I've really succinctly put it. My lord, there is a slight variation by the Supreme Court now. What they've said is they've given wide discretion to the learned arbitrator to decide on the interest. They say that the CPC is no longer binding on the arbitrator so far as interest is concerned. My lord, I can take you straight to the provision of section 31, which deals with interest in an arbitration.
Arbitration.
37.
31(7).
Not section 31, subclause 7. While the 1940 Act was there and initially before the, up till 5 years ago, the Supreme Court had said that rely on CPC, but there has been now very strict interpretation of the provision in the Act itself. So my lord, 7A says, unless otherwise agreed by the parties, where and insofar as the arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money, for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. So they have included both pre-suit and pendent interest in 7A, 31(7)(a). Because they say from the date of cause of action till the date of award, the learned arbitrator, unless the parties have agreed, otherwise agreed, can award whatever interest deemed necessary. Now, my lord, we look at B. A sum directed to be paid by the arbitral award shall, unless the award otherwise direct, carry interest at the rate of 2% higher than the current interest rate prevalent on the date of award from the date of award to the date of payment. So, my lord, so far as B is concerned, the Act says that if the award mentions a particular rate of interest, then that interest rate will prevail. If it is silent, in that case, whatever the prevalent interest rate is, 2% higher than that would be what would be levied on the award. Now, the Honorable Supreme Court, in the case of Morgan Securities and Credits versus Videocon, has in fact taken away the discretion from the arbitrator also to award interest. He says the interest post-award is mandatory. The arbitrator cannot even waive. Yes, ma'am.
This 7A
Yes,
was
ma'am.
always there or added later?
Now, this 7A was added post the 2016 amendment. So 7, my lord, may look at the substitution. It is mentioned in my Bear Act at least. It mentions substituted by Act 3 of 2016, Section 16 of Clause CB, with effect from 23rd October 2015. Prior to its substitution, be read as under. A sum directed to be paid by arbitral award shall, unless the award otherwise direct, carry interest at the rate of 18%. So instead of 18%, now it says interest from the date of 2% higher than the...
No, that is B.
Yes, my lord.
But what about A?
A was like this, my lord.
Always there.
Always there, my lord.
And your date of reference is?
Post 1996, my lord. It is 2005.
The learned arbitrator had granted you interest.
Yes, my lord.
And it was set aside by the court on what ground?
My lord, it was set aside on the ground that there is a clause in the agreement which, according to the Learned 34 Court, does not permit interest to be awarded. Pre-reference interest. So pre-award interest. So neither the pre-reference, neither the pre-award interest was given by the Learned by the 34 Court, but the post-award was upheld.
Which is that clause?
Yes.
Volume 2, page number 446.
My lord, volume 2, page 446. My lords, have that page? Yes. No claim for delayed payment due to disputes, etc. No claim for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer-in-chief on the one hand and the contractor on the other, or with respect to any delay in the part of the engineer-in-chief making periodical or final payments or in any other respect whatsoever. Now, as I was pointing out...
No, where is the finding of the learned judge on this?
My lord, yes, my lord. My lord, that finding is, my lord, page 251, volume 1. By learned judge, you mean the 34 court? Yes, my lord?
Yes,
Oh, yes. Yes.
the order appealed against.
Appeal direct, yes, my lord.
Page?
Page 251 of volume 1, my lord. There are 2 volumes, the first volume. It starts with para 56, the heading interest. And the finding specifically comes on para 63 onwards. First, the 34 court has quoted certain judgments, post which 63, page 262. it is settled position of law that the arbitrator is bound by the terms of the contract insofar as the award of interest from the date of cause of action to the date of award is concerned. Therefore, where the parties had agreed that no interest shall be payable, the arbitral tribunal cannot award interest between the date when the cause of action arose to the date of award. In the case, the arbitrator is awarded pre-suit interest on the claims. A summary of the pre-suit award interest awarded by the claimed and claimed by the respondent and awarded by the arbitral tribunal against each claim is as follows. Then the 65 is the quotation of the clause. 66 is the 31(7)(a) has been quoted, my lord. 67, a bare perusal of 31(7) of the Arbitration and Conciliation Act makes it clear that clause A relates to the period between the date on which the cause of action arose and the date on which the award is made, and clause B relates to the period from the date of award to the date of payment. In the instant case, the arbitrator has awarded pre-suit interest on the individual claim 2, 3, 4, and 5. Therefore, it has awarded pendentalite interest of 9% on the awarded amount from the date of arbitration tribunal entered upon reference till publication of award, and future interest of 9% on awarded amount from the date of publication of award till realization. Under clause 54 of the GCC, there is a specific bar to the claim for interest with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer-in-chief on the one hand and the contractor on the other with respect to any delay on the part of the engineer in charge making periodical or final payments or in other respects whatsoever. While awarding interest, under this head, the learned arbitrator did not discuss clause 54 of the GCC nor gave reasoning for awarding a pre-suit pendendite interest contrary to clause 54 of the GCC. In view of the express bar under clause 54 of the GCC, read with 31(7) of the Arbitration Act, the arbitrator could not have awarded pre-suit and pendentalite interest on the awarded amount. The award of pre-suit and pendendite interest in respect of 2, 3, 4 is against the provision of clause 54 of GCC, and to that extent, the grant of pre-suit and pendentalite interest is hereby set aside.
If you read the clause in the contract,
Yes, my lord.
it is in respect of money which is held by the corporation, it is lying with them,
Yes.
earnest, security, etc. But this claim is in the shape of damages and claims for work done, etc. How is it covered by the prohibition clause? That is the only point you have to answer. It is not prima facie. And the arbitrator seems to have been right.
446, bro. 446. Huh? My lord, it did that clause covers damages also, my lord. Your lordship will kindly.
Or damages.
440.
Money held.
My lord, I'll just, my lord.
No claim for interest.
My lord, may I read that, my lord?
Page 440.
46.
446.
My lord, we look at 263 itself, the clause is quoted there for my lord's convenience. The Honorable 34 Court, learned 34 Court has also quoted the clause. Para 65, page 263.
Huh?
263.
There's a there.
263, my lord. May I read, my lord? No claim for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference, or misunderstanding between the engineer in charge on one hand and the contractor on the other hand with respect to any delay on the part of the engineer in charge making periodical or final payment or in any other respect whatsoever. And my lord, this clause, my lord, your lordship will kindly see in the judgment itself, page
252.
Interest is a kind of damage. So that is why they have said no claim for interest or damages.
So that was covered, and my lord, this clause My lord, in Saeed's case, my lord, exactly the same.
For what? For money held by the corporation. Here the claims are not recovery of money held.
Compensation and damages.
No, it's not compensation and damage, my lord. It's a recovery, my lord.
Usually, it's a usual works contract claim.
Yes,
Please
my lord.
come to the claims.
Yes.
The amount of reimbursement on account of escalation in minimum wages.
Yes. 262.
262.
Deduction. Recovery.
Recovery, however, good.
Account of escalation of in minimum wages. Reinforcement. Deduction. Reinforcement scheme.
My lord, your lordship will find first is, my lord, on account of escalation in minimal wages.
Yes.
Secondly, please put interest.
Say minimum wages at the time of the contract was 2. On that basis, the value was fixed. This is the amount to be paid. Say, on the date of the claim, it is 5. So 5 minus 2, give me.
Exactly.
Please put interest towards unjust deductions towards reinforcement, still and refund of amount deducted. That was in account of deduction. All these amounts were, my lord, disputed and being not paid.
This reimbursement thing is not a correct expression used. It should have just been claim of
Yes, my lord.
15%.
It's not a reimbursement, it's a claim. Because those all claims were, my lord, disputed, my lord. And otherwise, my lord, it would have been paid to them.
What I'm claiming, 10% loss of profit.
Yeah.
That's all.
That-
No
that-
reimbursement business.
It's not
That
reimbursement.
is a
They say that since you have foreclosed the contract, so I am entitled to the, my lord, the profit of 10%.
that is all right. They have claimed that, got it. You have also paid them.
You are true, my lord.
Now the question is interest. Now you are saying that it is hit by this prohibition, this bar under this clause.
Yes, my lord.
That room. But that you go through it, it relates to only money which is held by the corporation. If money was held on their account, then on that money, they suppose the award was give back the money, refund the money, no interest was payable.
Yes.
It is usually security deposit or earnest.
Yes, security deposit and harassment. Your lordship will kindly see
Any other
again.
Or performance guarantee. Either bank guarantee or cash.
My lord,
If it was so, if it was cash guarantee, then no interest because it's money held by them.
no, my lord, your lordship will kindly see again, my lord, if I'm taking, my lord. Engineer in charge or any hand and contractor other with respect to delay on part of the engineer making or final payment or any other in any other respect whatsoever. Last line of clause 54, it pays 263, my lord will find.
this similar clause has been interpreted by the Supreme Court.
My lord, it's a wider terminology has been used, my lord, and this apex court has decided.
This qualifies delay with respect to any delay on the part of the engineer making periodical or final payments or in any other respect whatsoever. Delay or for any other reason money is held. Not all other claims are included.
Decided with the court.
And my lord, exactly the same clause has been already decided by the apex court that.
No, we are not expressing our final view. This is just tentative.
Let him correct me that.
By Justice Sanjeev Banerjee while he was chief here on the identical paramateria clause, wherein what my lord has fallen from my lord, that is exactly what he said, that this is too vague. Any reason whatsoever cannot preclude pre-suit interest. Relied on two Supreme Court judgments and upheld the pre-reference, the pre-suit interest, the pre-award interest. I will take my lord through those judgments.
Yes.
Now, yes. Now, my lord, there is one more argument that we are taking in this matter, which is that when the Section 11 petition was filed by us, we had referred to claiming this interest. And when the reference was made by the Honorable High Court, appointing the learned arbitrator, at that time also, the specific mention of interest was given. They had not taken this very objection while our Section 11 petition was being heard. When the arbitration proceedings were going on, they have not, in a single utterance of this clause has been made in the entire proceedings, neither in the statement of defense, neither in their counterclaim, neither in their evidence regarding clause 54. So the Honorable Supreme Court, in an identical case, where the clause was also paramateria, has said that this is a case of waiver, and now the government cannot come. This was a case against Union of India. They said the Union of India cannot now come and say we will apply this clause when they have stepped over the matter during the courts below. That judgment was cited before the learned 34 court, but the court has not considered this judgment. That is the judgment that has been provided, my lord. That is the judgment of Messrs. Susaka, Union of India versus Messrs. Susaka Private Limited. If my lord can take that judgment. My lords have that judgment? Yes. Para 3 onwards, my lord. In short, the question which arises for consideration in this appeal, my lords have it? Yes. In short, the question which arises for consideration in this appeal is whether the arbitral tribunal was justified in awarding interest on various claims for different periods to the claimant, namely for pre-reference period, 2 pendentalite, and 3 post-reference period, total of so-and-so on the awarded sum. So the identical question was formulated by the Honorable Supreme Court in this matter. My lord, may come to paragraph 6. Para 6 refers to the Section 11 order. The High Court, by order dated 27th July 2011, with consent of both the parties, allowed respondent numbers 1 application and referred various claims, claims 1 to 17, made by the respondent claimant against the appellant for their adjudication by the arbitral tribunal. Now, my lord, may look at the table. My lord,
Page 435.
for page 435, 1.6E. My lord, I have E. It says 1.8 and 2.3. Payment of light interest from so-and-so date to so-and-so date as accrued, and this is the claim. My lords have that. It's a table.
Last call.
Now, my lord, may come to page 436. The first sentence itself. The single judge made the interest payable from the date of award till realization. I'll read the whole paragraph. Actually, paragraph 9 from the previous page. The single judge, by order dated 21st April 2003, allowed the appeal in part and made 2 modifications to the arbitral award with respect to the date of interest on the claim of respondent number 1 for damages and on the claim of 1 purchase item. The single judge made the interest payable from the date of award till realization. So far as the challenge to other claims, including the award of interest on such claims, were considered, the single judge rejected the appellant's all objections and upheld the award in totality for all purposes. So exactly what happened in our case, my lord. The learned 34 court, in this case was the Honorable High Court, and they set aside the pre-award interest and only granted the post-award interest. The respondent number 1, claimant, felt aggrieved against this part of the order of the single judge that interfered in part in the arbitral award, filed appeal before the division bench. So far as the appellant Union of India was concerned, they did not file any appeal against the part of the order of the single judge which had substantially rejected their application filed under 34 of the Act. In view of the matter, the award to this extent has become final. Again, identical to my case, they have not filed an appeal against the 34 order and it has become final qua then. My lord, paragraph 11. By the impugned judgment, the division bench of the High Court allowed respondent number 1's appeal and set aside the order of the single judge. It was held that no ground under 34 of the Act has been made out by the Union of India to modify the award to the extent of awarding interest on the claim. In other words, the opinion of the division bench on the ground on which the limited interference was made by the single judge for setting aside a part of the award in relation to award of interest from a particular date on 2 claims was not ground falling under 34 of the Act, and therefore the order of single judge was not legally sustainable. It was accordingly set aside, resulting in upholding the entire award and dismissal of the 34 application in its entirety. My lord, we come to paragraph 14. The Union of India challenged the division bench's order before the Honorable Supreme Court. Now, this is the observation. According to the learned counsel, the arbitral tribunal misconstrued in awarding interest on various claims and therefore a ground to set aside the arbitral award under section 34 of the Act is made out. Placing reliance on clause 13.3 of GCC, learned counsel urged that clause 13.3 provides that no interest will be payable upon the interest, earnest money or security deposit or amount payable to the contractor under the contract except government securities. Respondent number 1 was not entitled to claim interest on any of the heads. In other words, the submission was that the arbitral tribunal misconstrued in awarding interest to the respondent number 1 claimant on their various claims when the clause 13 of GCC did not allow them to claim any interest on the sums payable under the contract except on government securities if deposited with the appellant. Lord, may come to paragraph 20. Now, Lord, this is the most pertinent point. It is not in dispute that the appellant did not raise the plea based on clause 13 of the GCC against respondent number 1 at any stage of the proceedings, either in reply filed before the tribunal and or the submission except raising it first time before this court in appeal. On the other hand, we find that the section 11.5 proceedings, the appellant did not raise the objection in the reply and instead gave their express consent to refer the issue of award of interest on interest payable on various claims under 1 to 17, considering the said claim to be arbitrable under the Act. In our opinion, the appellant could have registered their objection before the learned single judge at the time of making reference to the arbitral tribunal by pointing out clause 13.3 of GCC, or could have reserved their right to raise such objections before the arbitral tribunal. It was, however, not done. Not only that, we further find that the appellant in the reply filed in the arbitral tribunal did not raise the plea and allowed the arbitral tribunal to adjudicate the said issue on merits. If the appellant was so keen to place reliance on 13.3 of GCC to defeat the claim of respondent number 1 relating to the award of the interest on various claims, then it was necessary for the appellant to have raised the said pleas specifically in the reply before the arbitral tribunal. No such plea was ever raised before the arbitral tribunal. Now, my lord, may come to para 26. The last time, my lord. In light of the aforementioned factual scenario emerging from the record of the case, we cannot grant indulgence to the appellant Union of India to raise such a plea for the first time here. In our view, It is a clear case of waiver and or abandonment of a plea at an initial stage itself. Everyone has a right to waive and agree to waive the advantage of law made solely for the benefit and protection of the individual in his private capacity, which may be dispensed with without infringing any public right or public policy. If a plea is available, whether on facts or law, it has to be raised by the party at appropriate stage in accordance with law. If not raised or given up with consent, the parties would be precluded from raising such a plea at a later stage of the proceedings on the principles of waiver. If permitted to raise, it causes prejudice to the other party. In our opinion, this principle applies to this case. My Lord, paragraph 32. In our considered view, the grant of award of interest on arbitrable claims of the arbitral tribunal is not inherently illegal or against any public policy per se, bad in law or beyond the powers of the arbitral tribunal. In other words, it is permissible to award interest in arbitrable claims by the arbitral tribunal. Indeed, 31(7)(a), not so they specifically refer to 31(7)(a) and B of the Act empowers the arbitral tribunal to award interest on the sum, and secondly, it is always subject to agreement between the parties. So the Honorable Supreme Court notes that it is subject to the agreement between the parties. So I am taking a step further. Let us say this clause is applicable on us. Even then, by their waiver, they have especially waived their right to claim this clause. It is well settled in arbitration law that the award of an arbitral tribunal once passed is binding on the parties. The reason being that the parties have chosen their arbitrator and given him an authority to decide the specific dispute arising between them, must respect his decision as far as possible and should not make any attempt to find fault in each issue decided by him only because it was decided against one party. My Lord, paragraph 35, they've quoted the Honorable Bombay High Court, where the quotation, now we have often had occasion to say that when the state deals with a citizen, it should not ordinarily rely on technicalities. And if the state is satisfied that the case of the citizen is just one, even the legal defenses may be open to it. It must act, as has been done by the eminent judges, as an honest person. The aforementioned observation has full application to the case at hand, because here also the appellant pursued the technical legal point up to this court against respondent number 1 without even raising it at any stage of proceedings, much less to find out whether it would be a ground to set aside under 34 to seek its setting aside. All this was done to defeat respondent number 1's claim of interest, which was rightly awarded by the arbitral tribunal and applied by the courts below this ground. In view of the discussion, we find no merit in the appeal and which thus fails and is accordingly dismissed. Am I not to justify?
Yes.
Yes. Now, my Lord, to substantiate this matter with my pleadings to justify what has happened, my Lord, I would like to take my Lord straight away to section 11 filed by me, which is on page 485, my Lord, of the paper book, volume 2.
देखो पीछे देखो क्या बोलो आप नहीं जानते हैं ना क्या एक चेयर तुम लोग ठीक नहीं कर सकता
Volume 2. Page 485. This is the section 11 petition filed by us.
जो बोला है वो चल रहा है 485.
Yes, my Lord. Volume 2, my Lord.
Who was the learned arbitrator?
Lord, it was retired Justice
Of this court?
No, my Lord, of the Delhi High Court, Honorable Delhi High Court. The arbitration took place in Delhi. by the consent of...
Date of the award?
My lord, the award is dated 2012, my lord. 3rd May 2012, my lord. Sorry, 5th June 2015, I apologize. 5th June 2015. 2015 is the date of award, 5th June.
Which honorable judge?
Justice J.K. Mehra, retired justice. He's in fact recently passed away. Yes. Yes. Let's have page 485.
Yes. 482.
Yes, my lord. 485, my lord. I apologize for the confusion. Let's have it. It starts with in the Guwahati High Court. The High Court of Assam, Nagaland, Meghalaya.
Part 2.
Yes. Now, as my lord would see, this is the section 11 petition filed by the appellant on 14th September 2005. My lord, the relevant part, my lord may come to, is page number 489. I don't have it. My lord, page 489 from clause E onwards. The second clause, my lord, E, page 489. My lords have it. Whether the claimant contractor is entitled to get interest for pre-reference period, then F. Whether the claimant contractor is entitled to get interest pendentalized. G. Whether the claimant contractor is entitled to get post-award interest. Accordingly, according to the claimant contractor, it is entitled to get an amount of more than 3 crores plus interest, costs, etc. on various heads from the respondent. My lord, this plea was specifically raised by us in our section 11. Now, my lord, the Honorable High Court, in its order dated 14th September 2005, on page number 131, my lord, unfortunately it's on volume 1. I will request my lord to take the other volume. It's also in this also? Sorry, my lord, we come to page number 495. In this volume, volume 2 itself. My lord, have it. My lord, some of the claims are mentioned, and underneath that, it is the case of the petitioner that though it is entitled to receive more than 3 crores plus interest costs, etc. on various heads from the respondent, but the latter has refused to settle the disputes amicably. According to the petitioner, this prompted him to issue notice dated to 2nd June 1999 upon the respondent to refer the aforesaid dispute to arbitrators in terms of clause 70 of the aforesaid agreement. After receiving the notices by the letter dated so-and-so, the petitioner was informed that the respondent has appointed Shri so-and-so as their arbitrator. It may be noticed that the petitioner by its letter dated 23rd March 2002 had earlier informed the respondent that it had appointed Justice S.S. Chadda, Judge of Delhi High Court, as its arbitrator. At this stage, it may also be noticed that the respondents by letter dated referred the disputes concerning the claim for so-and-so for arbitration. The respondents, however, refused to refer the disputes.
Which page you are reading? 498?
My lord, 497.
Okay. Yes, yes, sir.
Yes, 497. But essentially, there were various claims that were being raised by us. So disputes arose between the parties. Just to give my lord context, we were awarded this contract in 96. We were not handed over the project or the drawings till 2001 when the project was foreclosed. So work could never be initiated properly. The labor was waiting there. Everybody was waiting there. So in 1999 itself, we had asked them to refer the matter to arbitration. But the respondent kept refusing and delaying the matter. So eventually, when they referred some of the claims to arbitration but refused to refer our other claims to arbitration, we had to approach the Honorable High Court. My lord, may come to page 498. My lord, have it. My lord, about 8 lines from the top, from the bottom. Learned counsel for the petitioner in the course of hearing. My lord, have that line?
Yes.
Yes. The learned counsel for the respondent, petitioner in course of hearing has decided not to press before this court for directing the respondents to refer the disputes concerning unjust deduction towards reinforcement steel to the arbitrator, but reserves his right to agitate this point before the arbitrators. It is, however, contended by the learned counsels for the petitioner that even though the arbitrator has been appointed by the parties as early as 2003, the proceedings have not at all commenced due to the dilatory tactics adopted by the respondents. It must be pointed out that the arbitration mechanism has been introduced by the legislature as an alternative dispute redressal forum for speedy disposal of the disputes between the litigants and to minimize litigation in normal courts. The laudable scope could not be lost sight of by the parties. On the facts and circumstances of the case, no serious question of law survives for consideration by this court, but the direction is called for ends of justice. In the result, application is disposed of that the arbitrators already appointed by the parties shall now commence the arbitration proceedings in accordance with law without further delay and within a period of 3 months from the date of receipt of this order.
You see, the principle is very simple.
Yes, my lord.
It is all right as laid down by the Supreme Court, but a point of fact which you have not taken before the trial court cannot be taken on appeal.
Yes, my lord. Yes, absolutely. That's the principle.
Because you have not taken it before the arbitrator.
Correct, my lord.
There was no issue before the arbitrator. Because this is not a question of law can be taken at any time.
Yes, my lord.
So this fact, whether it is covered by the contract, barred by the contract, etc., these are questions of fact.
Correct, my lord.
It's not taken before the arbitrator.
Correct, my lord.
So the learned arbitrator, while awarding the claim,
yes, my lord,
very smoothly went and awarded interest.
Yes, my lord.
Because it was not raised, claimed interest as of right he gave.
Absolutely, my lord.
Under 31(7).
Correct, my lord.
Because there was no
The clause was never pointed out to him to actually adjudicate on the same.
Yes, because there was no issue raised under
Absolutely,
31.7.
my lord.
Then it went before the
34 court.
34 court.
Yes, my lord.
At that time, it was taken for the first time.
No, even there, my lord, it was not taken. In only for one claim it has been taken, and it has not been taken for pre-reference period. So that's the pleadings I want to show, that they are not even taking it in the 34.
That is, the 34 is to be taken as equivalent to the appellate court.
Absolutely.
So
my lord.
this appellate court, whether it was at all proper for the court to entertain the point when it was not
Precisely.
before the trial court.
Absolutely, my lord.
In addition to what their lordships have held in this judgment.
Yes, my lord.
And what you show us Justice Shonji Banerjee's judgment.
Yes, my lord.
You can show from here because it's 96.
State of Maryland.
My lord, the first paragraph itself makes it clear that this matter pertains to an arbitration under the 1996 Act. Just to, it says an arbitral award in proceedings under 34 of the Arbitration Conciliation Act 1996. Now, my lord, may come straight to para 31. My lord, sorry, para 29. Have it. The final limb of the argument. My lord, have that para? Yes. The final limb of argument pertains to award of interest. The appellants have relied on para 34 of a three-judge bench in the case of so-and-so. I'll not read that, my lord. Even without referring to any material on the basis of the binding law as laid down in para 34 of the judgment in so-and-so, it is evident that there is no merit in the appellant's suggestion that by virtue of a relevant clause in the contract between the parties, no interest could have been awarded in favor of the contractor. Clause 39.1 of the GCC, which is relevant for the present discussion, provides as follows. My lord, this clause is quoted here. If my lord want to compare this clause with the clause in our matter, it is identical. The only difference is the word here used is department, and in my case the word used is corporation. Besides that, there is not even a comma that has been changed in this clause. I will read this clause, my lord. No claim for interest or damages will be entertained by the department with respect to any money or balance which may be lying with the department owing to any dispute, difference or misunderstanding between the engineer-in-chief on the one hand and the contractor on the other, with respect to any delay on the part of the engineer-in-chief in making periodical or final payments or in other respects whatsoever. On a plain reading of such a clause, it is apparent that the clause prohibits payment of interest in certain specified cases, and it also contains a residuary limb in the words or in other respects whatsoever that ostensibly precludes the payment of interest on any account. However, the dictum in so-and-so instructs that unless the payment of pendentalite interest is specifically prohibited, a general bar of payment of interest will not be interpreted so as to include a prohibition as to pendentalite interest. The principles of party autonomy permits the exclusion of certain ordinary rights, but such exclusion has to be express and specific and may not easily be inferred unless unambiguously stated. My lord, may come to para 35. The other argument that has been taken by them also was on the higher quantum of interest rate. That para 35 deals with that. The award of interest at such high rates does not call for any interference. First, in view of section 31 of the Act, it is the prerogative of the arbitral tribunal, subject to any agreement between the parties as to what should be the quantum of interest. Secondly, considering that the contract in this case was the year 1996 and dues have not been cleared yet, a reasonable quantum has been awarded by way of interest by the arbitral tribunal and does not shock the conscience of this court for it to be interfered with. Lord, identical case, I have a contract of 1996. Interest has been awarded in my case. The clause is identical, just that it is the state of Meghalaya instead of the NEPCO, which is the PSU. My Lord, para 43, for the reasons stated above, there is no merit in the appellant's challenge to the arbitral award. Accordingly, so-and-so is dismissed with cost of rupees 2 lakhs on the government. Now, this judgment was challenged by the state of Meghalaya in the Honorable Supreme Court. I will pass on that order also. By consent, the Honorable Supreme Court reduced the interest because the petitioner wanted to bring the respondent wanted to bring quietus to the matter, recording that they want to close the litigation and dispose of the matter. So far as the law is concerned, this judgment has been upheld by the Honorable Supreme Court. If I can read the relevant part, my lord, the second page. P. Sham Diwan, learned advocate appearing for the respondents, has stated at the bar that to put an end to the litigation and to have a quietus, the respondents are agreeable to forego the interest awarded at 10% from so-and-so and is ready to accept interest at the rate of 12% on the date of award till realization. In that view of the matter and the gestures shown by the contractor, we modify the award by the learned arbitrator and it is directed that the amount awarded by the arbitrator shall carry interest from the date of passing the award till realization. To that extent only that the judgment and the award passed by the learned arbitrator confirming by the High Court is hereby modified. The present appeal stands as present special leave petitions stand disposed of accordingly to the above extent. Now, just before that, I wanted to point out, having heard the learned counsel for the respective parties and having gone through the impugned judgment and the order by the Honorable High Court, we see no reason to interfere with the award passed by the learned arbitrator confirmed up to the High Court in the proceedings under 37 of the Arbitration Act. And the court has given a categorical finding that there was no problem, but just to bring a quietus instead of avoiding a long-drawn argument and litigation, the contractor consented and this was done. Just to bring everything to my lord's knowledge, this judgment is being shared.
You've nearly covered all the points.
Yes, just want to show you the pleading, my lord, in the arbitration that the claims where we have specifically sought for pre-reference and pendent-lite interest.
Not necessary.
And they have not replied to it also. They have not even...
In their counter statement.
Yes, yes, my lord, absolutely. They have only denied pendent-lite interest. That's just one page.
No, we have taken note of your submission that section 11 taken, not denied, no in pleadings or otherwise, and in the arbitral proceedings also not. So we'll give you an opportunity to file written notes. There you give the details.
Very well, my lord. So
you've concluded.
My lord, there is My lord, I have one or two more judgments to show, my lord. I can show it on the next date.
No. Please, you give us the proposition, show us the judgment. Finish it up.
Yes, my lord. So, my lord, in the 34, though they had not taken arguments in writing, at the time of arguments of the matter, they had taken 3 different arguments qua interest.
Yes.
Yes, ma'am. So, like my lord have already noted, in the 11 and 34, they have not taken reference to the clause, but while arguing the matter, they had taken 3 objections to the interest. One was, my lord, that interest on interest cannot be awarded.
Yes.
Because they said that if I am claiming interest from the date of cause of action till the date of filing of my claim petition, and then on top of that, I am claiming interest on the award that is passed, then that amounts to interest on interest and it is barred. That is one objection that they have taken, my lord, that it amounts to compounding of interest, which is not permissible. The second objection they took was qua the quantum of interest, the percentage that the interest awarded is very high. And the third objection they took was regarding this clause. Now, this judgment, my lord, deals with the interest on interest aspect. So, just to cover all bases.
This judgment?
Yes, my lord. Morgan, my lord. Yes, my lord. So, this judgment says 2 things. That post-award interest is not even the discretion of the learned arbitrator. He can choose the quantum, but post-award interest is mandatory under the eyes of law. So, it has to be given irrespective. The arbitrator cannot say no interest will be awarded post-award. The only discretion that lies is choosing the quantum of interest post-award and whether interest is to be given or not pre-award. Now let me come to para 22 straight. Let's have para 22.
Yes.
Para 22 subclause 2. Justice Bobre's opinion in Hyder Consulting held that the arbitrator may grant post-award interest on the aggregate of the principal and pre-award interest. This opinion did not discuss the issue of whether the arbitrator could use their discretion to award post-award interest or the part sum awarded under 31(7)(a). Well, basically, this is the point that Hyder Consulting was upheld, wherein they said that interest on interest is permissible in arbitration, unlike suits where my lords have held that it is against the Law Interest Act and other provisions.
Where are you claiming interest on interest? You are claiming on those claims 1, 2, 3, 4,
Yes,
etc.
my claim is, my cause of action arose in 2001. Now I have claimed interest from 2001 till the time the reference was made to the learned arbitrator in 2012. Then the pendent right interest from 2012 to 2015. And whatever the amount comes, on that amount, I am claiming interest on the date of from the date of award. On the sum, the total sum, principal plus interest, on that sum, the award is where the interest is being claimed. So the Supreme Court, this issue was specifically raised because people were saying this amounts to compounded interest, which is not permissible. The Honorable Supreme Court clarified, and this is a 2024 judgment, which clarifies.
31(7) permits that.
Exactly.
On that award,
absolutely.
on the award interest.
Absolutely, my lord. Yes, that's the whole point. That's the interpretation. The court has upheld it. Now, my lord, there is an aspect to show the delay on their part, my lord, wherein for 12 years the arbitration could not even commence, and how equity-wise also.
Because compound interest has to be specifically excluded.
Correct.
Because otherwise it is always compound.
Yes, my lord.
But they use the term, the bank and all that, they use the term yearly rests.
Yearly rests.
That is, if you deposit for 1 year, say it's 8% interest, 1,08,000. Next year it starts from 1,08,000. It is not calculated from 1 lakh.
So 1 lakh plus the 8,000 becomes 1 lakh.
That becomes the principal.
That becomes the principal.
They
That's
call
the
it
rest.
yearly rest.
Yes, my lord. Absolutely, my lord. So
But then if it compound interest and also in other words compound.
Yes, my lord.
But if it has to be excluded, it has to be specifically
excluded.
So simple interest will run from 1 lakh for all the years.
Correct, my lord. Correct. That's absolutely correct, my lord. And the Supreme Court basically clarified that the awarded sum will carry interest even though pre-award also interest has been awarded. Now, just last two things that I have to show, my lord. If my lord will come to the award. Volume 2, page number 501. My lords have volume 2.
Yes.
Yeah. Page 501. It starts with the heading award. My lords have that?
Yes.
Yes. First paragraph talks about the work order, which is 1996. Then my lord may come to the last paragraph. It talks about the extensions being granted. My lord may come to page 502.
Yes.
My lord, the third paragraph, my lord, or the fourth paragraph, the claimant APCL invoked arbitration with respect to. My lord, have that paragraph?
Yes.
Reimbursement of minimum wages of unjust deduction towards reinforcement steel by its letter dated 13th October 1999. I just want to show this note that what went through with the learned arbitrator to award this kind of interest to us, which is not high according to me, but interest being awarded to us. So in 1999 itself, my lords, have that date? By its letter dated 13th October 1999. Will it have that part?
Yes.
Yes. So from 1999, we have been requesting that arbitration be proceeded against. Arbitration proceedings be initiated. Now, my lord, the next, the second last paragraph is very, very important. However, thereafter, no proceedings could commence. May not have that line in this paragraph only, about 8 lines from the bottom. However, thereafter, no proceedings could commence.
Yes.
Yes. However, thereafter, no proceedings could commence. Accordingly, the claimant APCL approached the Honorable High Court of Guwahati at Agartala bench under Section 11 of the Arbitration Act to seek appointing of learned arbitrator vide arbitration petition number 15 of so-and-so. The Honorable High Court, vide the order dated 14 September 2005, disposed the petition categorically recording that after the nomination of respondent's arbitrator, no proceedings would commence due to the dilatory tactics adopted by the respondent NEPCO. The Honorable High Court therefore directed the parties to commence the proceedings with the arbitration already appointed by the parties with immediate effect and without any further delay. Vide intimation dated 10th November 2006 the undersigned was appointed as the presiding arbitrator. By letter dated 8th March 2007, the undersigned entered into reference and fixed date for preliminary hearing. However, once again, there was delay on the part of respondent NEPCO to commence the arbitration proceedings despite issuance of letter dated 13th July 2009 by the undersigned. Accordingly, the undersigned was constrained to issue a letter dated 4th October 2009 to the claimant APCL to take steps in accordance with law. The claimant APCL filed an application number so-and-so for appointment of fresh arbitrators. By order dated 31st January 2012, the Honorable High Court of Guwahati at Agartala bench appointed the undersigned as the sole arbitrator upon the consent of the parties. So, my lord, I have initiated my claims in 1999 till 2012. NEPCO is not even letting arbitration commence. I'm just showing on equity how they have delayed the matter.
That's so we've got your point.
Yes, yes, my lord. Para 70, if my lord can just note down, I'll not read it.
1770,
my lord, page 525. Should I read this, my lord, or my lord have noted it down?
we have noted it.
Very well. And my lord, I had filed a written submission, about a 5-page written submission at page before the learned 34 court, which actually deals with all the issues. It's a 4-page written submission on page 115 of this compendium, volume 1. It notes down their argument, it notes down my argument, and it deals with all the laws that I was relying on. So I don't want to take my lord through, I'll not take my lord through that, but just that my lord may look at it when.
So you want to use those written submissions here?
No, I believe, my lord, the reason I was showing this was that I wanted to point out that this judgment of Susaka that has been relied upon by me is referred specifically in this submissions and dealt with me in great detail. In fact, it goes on to record relevant paragraphs of this judgment also. But the 34 court has ignored this judgment while passing its order and ignored the principles of waiver.
Last submission of 34 very limited jurisdiction.
And my lord, have already in all judgments I've held that 34 jurisdiction is very, very limited.
Written submissions in which at which page?
My lord, page 115, my lord. Volume 1. Patent illegality is and policy. My lord, these are the only public policies. These are the only two grounds when an award can be. It's not can.
Section 28, contract.
My lord,
decide according to the contract.
Yes.
Then
Yes.
you would be hit.
Yes, my lord.
And that, if you don't decide according to the contract, you violate Section 28.
Correct.
If you violate Section 28, immediate patent illegality.
Correct.
But then you are overcoming that terms of the contract by these various judgments.
Yes, my lord.
Please take down.
Much obliged.
Learned counsel, so and so, learned counsel for the appellant. Resumes his arguments and concludes the same today. Paragraph. So and so, learned counsel for the respondents seeks time to get ready in the matter. Paragraph. Accordingly, by consent of learned counsel for the parties. When should we fix it?
My lord, just suggesting, my lord, to 3rd of February, my lord.
At the period.
3rd of February, if not inconvenient to my lord.
Lord, sir, take it next week.
My lord,
Make it next week.
3rd
The
of
week
February.
thereafter.
December.
3rd of February, you said. Then why are you coming back to this?
My lord?
3rd of February, you said.
Yes.
Second week of February.
Second, I'll not be there. I'm going abroad.
That's what the court wants.
My lord, I'll be, my lord, from 16 onwards, I'll not be here. I'm little going abroad, my lord. My daughter is there. Huh? 10th I can, my lord. 10th I can.
Second week also.
10th I can.
When will you be back? This month you are leaving.
No, not in February. I'm telling my lord.
When?
As February, my lord, I'll be leaving on 16th of February.
No, we will keep it on 10th. 10th or 11th, Tuesday we will keep it.
Let it be on 10th, my lord. Then 10th of February, my lord.
Which date is free? 13th February.
Oh, yes.
But you finish it on 13th.
No, my lord, I'll definitely, my lord. My lord, I have taken note of, my lord, what is fallen from my lord's mouth also.
Yes.
I'll make my submission on that. And whatever they are trying to say and all that, we will definitely make submission. We'll conclude on that day.
But can I request it be 13th and 14th just in case it stretches?
No,
So
no,
that
you
it
finish it on 14th.
Yes.
This appeal is list this appeal on 13th and 14th February to hear the respondents' counsel and
You're saying 14th.
learned counsel for the appellant in reply. You compress your reply and finish it.
Absolutely.
13 and 14.
My lord, I'm making it part-heard?
Yes.
My lord, I'm making it part-heard because the order doesn't record it. My lord, I'm making this matter part-heard because the order doesn't record
This is being live streamed. We are recording arguments that are why the further requirement of saying partner. Tell us.
Not at all, my lord.